correct that. I think when you're looking at the statute language, the legislature is enacting laws to have a purpose. The presumption is that the legislature does not enact meaningless legislation. If you are to follow the Department of Revenue's position, essentially petitioners would be raising these issues for the court to tell them either yes or no, there was a violation of some constitutional right. However, I have no remedy for you. And that would render this legislation meaningless. And so we do not believe that that is the intent of the statute, nor do I think you even need to get to that point, because I think on the plain language of the statute, it is clear that they intended these issues to be raised, not for some superfluous purpose, but so that petitioners could have a remedy. In the Martin case, there's discussion about the balancing test that was done, and that this was done to address public safety concerns. I don't believe that allowing constitutional issues to be raised at a trial court level on these type of hearings creates any public safety issue. An officer still is able to pull over a vehicle that it observes to be impaired either by committing an actual traffic infraction or some other reasonable suspicion that they can articulate. What this is stopping is baseless searches and baseless stops. We are not putting any additional burden on law enforcement. It is the same standard that they have to apply in the criminal context. There's not going to be an additional burden put upon them. And I also don't think that this is a situation where if you find the statute allows for the court to issue these remedies, that there'll be a floodgate. The burden is still on the petitioner. It has to go through the administrative proceeding. It has to appeal to the district court level. And then the court still has to find that there was no reasonable suspicion for the stop. And so I think the legislature recognized that this was an issue. It took the appropriate steps. This is not a judicial created remedy. This is something that the legislature took. Martin had been in effect for 8 years, and our position would be that the district court was correct in finding that there was no reasonable suspicion and correct in overturning the administrative license suspension.
The legislative history is full of references to the Martin decision, correct?
Correct.
Which would sort of indicate to the court or anyone reading the amendment that the purpose of the amendment was to essentially abrogate Martin. Is that a fair statement?
Yes, that's my position. And if there are no further questions, this was sort of a narrow issue. I would waive the rest of my time.
Any other questions?
Well,
Thank you. You're never penalized for giving up some of your time. Thank you very much, and welcome to your first argument.
Based on opposing counsel's argument, I don't have anything further to add, and I'd waive my rebuttal time unless the court has further questions.
Thank you very much, counsel. Thank you both. We'll take this matter under advisement and get to a decision as soon as possible. Last case is State versus Weaver. The parties will state their appearances.
Good morning, Your Honor. May it please the court, Jacob Gonteski on behalf of the plaintiff, the appellant, the state of Kansas.
Okay.
Good morning, Your Honor. Mr. Weaver appears to counsel Adam Stolten.
Okay, thank you. And did you wish any rebuttal time?
If I could reserve 3 minutes.
Okay.
Thank you.
Whenever you're ready.
Thank you. One Friday afternoon, James Trent was driving home at 175th and 169 highway here in Johnson County, Kansas. It's a busy highway speed intersection with a traffic light. Excuse me. James Trent was stopped at the red light, several cars back in traffic, when the light then turned green, but traffic ahead of him failed to move. When it failed to move, the traffic ahead of him started going around another vehicle that remained stopped in his lane of travel. When James Trent started going around that vehicle, he looked over and he realized the driver of that vehicle was slumped over the steering wheel and appeared unconscious. So James Trent pulled over to the side of the road and approached that vehicle. He got out of his own and walked over to the driver's side of what turned out to be Ralph Weaver's vehicle. And he started rapping on the window, trying to arouse Mr. Weaver. Unsuccessfully, he smacked on the door and he called 911, and he was unable to wake Mr. Weaver. He got 911 on the line, told them of what was going on. He began reaching through the window, hoping that perhaps he could unlock the door. He realized Ralph Weaver's vehicle was in drive while Mr. Weaver was behind the wheel, apparently unconscious. He tried to reach through the window to unlock the door and then startled Mr. Weaver, and Mr. Weaver finally woke up before officers arrived. And when he woke up, he said, "I got to get out of here." And he began leaving. And Mr. Trent said, no, you should stay. Somebody should check you out. Somebody should see what's going on. Mr. Trent stuck around. Mr. Weaver started to pull away just as officers arrived. And when Deputy Purdon arrived, he found Mr. Weaver's vehicle turning through the intersection, and Deputy Purdon immediately stopped Mr. Weaver. They pulled to the side of the road, and Deputy Purdon approached Ralph Weaver and said, "What's going on, man?" And Ralph Weaver was a little out of sorts and said, "Oh, I don't know. And he said, "Well, I just got a call that you were passed out behind the wheel. You were slumped over the wheel. Is something going on?" And Ralph Weaver said, "Well, maybe I must have just fallen asleep for a minute." And the officer said, you can't be falling asleep behind the wheel on an intersection like this on a Friday afternoon at 3 o'clock. And Ralph Weaver said, "Oh, I realize that, man. I realize that, but I'm fine." And Deputy Purdon, as he noted when he testified, he did say at the outset, "Have you been drinking? What's going on here?" And he said, no, I haven't been drinking. I was on my way to go to the Missouri side to buy some cigarettes where they're cheaper, but I haven't been drinking. And the officer then said, "Well, do you have some medical issues? Is this a medical episode going on?" And he said, "Well, I do have a lot of medical issues. I'm on a lot of prescription medication." Deputy Purdon noted that MedAct Medical was en route to check him out. And the deputy said, I don't know what's going on here. Did your blood pressure drop out, or what's going on?" And he said, "I don't know. It could be. I'm on blood pressure medication." So medical was on their way, and Deputy Purdon already knew something was amiss here. Deputy Purdon had a reason to stop Ralph Weaver that day. The initial stop was not questioned.
Interrupt you. I wanted you to lay the facts of the case, but
Yes.
now the judge suppressed the evidence, which is why the state's appealing this case.
Correct.
And in the Appellee's brief, they say that our court has no jurisdiction to hear this case
Right.
because your notice of appeal was untimely.
Right.
And you didn't file a reply brief to respond to any of that. Before you get into the merits of the issues here, please address the jurisdiction issue.
I'm happy to. If we go through the timeline on the jurisdiction issue, the hearing was held on the motion to suppress on July 12th.
Yes.
At the conclusion of that hearing, the judge he noted he was suppressing the evidence. He did not issue a written order, nor did he indicate from the bench whether he was going to or not.
But he clearly granted the motion to suppress.
Unquestionably.
All
He
right.
granted the motion to suppress and was silent on whether he would issue a written order.
Correct.
The state noted at the conclusion of the hearing that it would like to reserve the opportunity to potentially appeal or file a motion for reconsideration, asking the district.
Does that matter to anything?
I believe it does. I believe it does to the extent that the district court never indicated it was not open to such a request. The district court never said, "I'm not going to reconsider this. This is a final order. I'm issuing it today. That's it." The district court never said as much.
Maybe the judge expected some sort of timely motion to reconsider.
Well, when the judge, and the motion was timely to the extent that the judge set the case out and said, "Let's set it out, and we will come back. If you have filed something when we come back, we'll take it up."
Did the judge actually say that?
He did not, but by setting it out to another date, that was affording the state to make their filing. And they set the case out to August 1st by agreement of everybody in the room. And when the case was set to August 1st, before the parties convened August 1st, then the state filed its motion for reconsideration. and then the parties convened in court on August 1st.
So I'm a little foggy on the facts. They set the August 1st date right there at that first hearing.
At the end of the motion to suppress hearing, it's at the end of the transcript, they set the August 1st date. And the state's line, and I believe I quoted the state, but the state said we would like to reserve the opportunity to potentially appeal and potentially file a motion for reconsideration. The state then deferred to defense counsel on how to set the case. The court offered a scheduling conference of August 1st, and defense agreed to that. And then it was after that date the state filed the motion for reconsideration, and then the parties convened on August 1st. Because the state...
Didn't defense counsel say at that hearing that he had an issue with the court's jurisdiction?
He did. When they got back on August 22nd to take up the state's motion for reconsideration, defense counsel did argue that the state was out of time.
Judge didn't make any ruling on it, though, right?
Well, he didn't explicitly talk about the timeliness of the motion, but he did say he had jurisdiction to consider the motion for reconsideration. So he did rule on defense arguments' claim that the motion shouldn't even be heard. And the judge did say at that time, I believe the motion is properly here before me. I will entertain it. And then the judge revisited some of the arguments the state had made in the motion for reconsideration and talked about some of them. The judge rejected other arguments that the state had offered in the motion for reconsideration, saying, those are new arguments you never made before, I'm not going to take those up.
Does your whole argument hinge on the fact that they set the August hearing date in that first hearing?
It hinges on that and the fact that the judge did not issue a written order and was silent on whether he would or not.
Well, if the judge didn't issue a written order, the only thing we have is the July 12th ruling where the judge clearly denied the motion to suppress.
The judge did later issue a written order. After the August 22nd motion for reconsideration, a written order was filed memorializing what had taken place.
In your brief, on page 10 of your brief, you say just the opposite. You say that no written order was ever filed in this case.
It wasn't, but it was later, and it's part of the appellate record. It was filed on September 11th of 2018. It's volume 1, page 11.
When the appellee filed a brief clearly challenging our court's jurisdiction, and you don't even reply to that, why shouldn't we just say you lose?
You shouldn't say I lose, because when you look at the case law on this sequence of events, the case law shows that jurisdiction still holds.
How do we know that case law if you didn't tell us what it was? I mean, you didn't argue any of that case law.
It's true. I'm here to argue it today, but I did not put it in a reply.
Okay, so what case law supports your position?
The case law that supports the position is State v. Campus, 2014 Westlaw 408-2408, states that when no written order issues immediately but does later, that date controls for the purposes of a notice of appeal of that order.
What did you say? That it was state versus what?
State versus Campus, C-A-M-P-A-S.
Thank you.
2014.
I got the sign.
Okay.
I didn't
But-
get
Oh,
to
sorry.
finish out the
Okay.
site again.
2014 Westlaw 408-2408.
And so you didn't feel compelled to give us a reply brief to cite this case that you're now telling, an unpublished case that you're telling us is on point?
I wish I had.
Yeah, would have been a good idea.
It would have. I could revisit, I could pull my calendar up before me from when these briefs were being filed, but it's something I should have taken my time to do, clearly.
Counsel, should we say you've abandoned that issue because you haven't briefed it, even when specifically challenged on that issue?
I have not waived the issue of jurisdiction.
Well,
when-
if you don't respond to it, don't we usually say, and that's usually because the defendant has been making the argument, don't we usually say that if you don't argue it, if you don't brief it, you are presumed to have abandoned it?
If I don't brief it at all, yes, but I believe I sufficiently briefed jurisdiction and preservation in my original brief when I laid out the sequence of events. And actually, the motion
Are
for...
those the same, preservation and jurisdiction? Are you saying they're the same thing?
I overlap them, absolutely.
But they're
it-
not really.
To the extent that timely preservation by the state is required to vest this court with jurisdiction, they are the same to that extent. I'd also point out, if the state's motion was untimely, then presumably the district court judge was erroneous for even entertaining the motion for reconsideration. He made it clear when he set the date out that he would entertain that motion. When the motion was filed and it got set for a hearing date on August 22nd, he actually entertained that motion. 2 years ago, in State v. Evans, this court, this panel, sitting at this school 2 years ago this month, took up State v. Evans and clearly stated that a district court has jurisdiction to entertain a motion to reconsider. It can entertain that motion to reconsider at any time it's raised. It can even entertain that motion for reconsideration at trial. This panel stated clearly the justifications for that, which are absolutely reasonable.
So what's the side of your Evans case?
Excuse me?
Evans. Do you have a
Evans?
side on that? I presume it's not in the brief you didn't file.
While I'm looking for it, I will point out that in State v. Evans, the issue was raised, and the reason why this panel said that the district court has jurisdiction to continue entertaining such is because if the district court can entertain that idea in the middle of trial as the case proceeds, then the district court should equally be able to entertain it before trial at any time that it's raised. I thought I had Evans before me. I don't have it in the page that I have here. It's a 2017 case from this court. Jurisdiction was
Why don't, in the very little time you have left, why don't you briefly address them? Let me ask you one question on the merits.
Please.
What bothers me about this case is that your officer was conducting a DUI investigation at the same time they were checking on the health of this driver. Two things were going, you kind of had a public safety stop and a DUI investigation going on at the same time.
If you watch the video, which I hope this court has had an opportunity to do or will do, from the outset, Deputy Purdon did ask initially whether or not Mr. Weaver had been drinking. But after that, Deputy Purdon's focus was clearly on the medical issues. He asked him about medication. He talked about his blood pressure.
Yeah,
Deputy
but
Purdon is
He was
trained.
doing alphabet tests and things like that.
That came after MedAct had arrived and evaluated Mr. Weaver behind the wheel, and Mr. Weaver said he was resisting any further medical treatment. Medical was being cleared before the alphabet test was ever administered. That's the time that it broke. That's the time that the EMTs were clearing the scene. They were telling the officers, he doesn't want to be transported, he doesn't want anything further from us, we're going to leave. And the deputies immediately then asked him the alphabet test. The only extent of a DUI investigation that occurred before that was that as the deputies were waiting for MedAct and talking to him about medical issues and medication, they made observations that they didn't detect an odor from him, that they asked him if he had been drinking, and he said no. And one officer did tell the other one, I do see his eyes shaking, which is a sign of intoxication. And so the officers were not engaged in a DUI investigation at the time the priority was placed on the medical issue. When medical began to clear the scene, that's when officers then went into gear on a DUI investigation. To say that they were erroneous to do so would require these officers to turn a blind eye to clear evidence of intoxication. Mr. Weaver was clearly intoxicated that day. And to tell deputies that because they had asked Mr. Weaver if he had been drinking when they encountered him when he was passed out behind the wheel, that tainted the investigation would present a horrible incentive for officers to start ignoring these types of facts on this type of call.
If there are no other questions, I think you're out of time. I'll give you a minute in rebuttal, but
Thank
we've
you.
used all your time.
Good morning. Adam Stolte appearing for Mr. Weaver. I'll just go through my brief in order unless the court has any other questions I'd like to jump ahead to. I think my sub-issue 1, that this court lacks jurisdiction, controls this matter, was not able to pull up Evans or Campus as Mr. Gonteski was speaking. But the facts I gleaned from Campus was that you jump back to the date of, and I think that would jump us back to the date of the motion for reconsideration, not for the motion to suppress hearing, in which case 3603 controls, the 14 days have passed, and this court lacks jurisdiction to hear this case at all. At the close of the motion to suppress hearing, it seemed clear to me that the state, the prosecutor, was going to go back, talk to the other prosecutors, make a plan. I think it would be at that point that plan would have to include 3603 and the 14-day time limit, or to move forward without that, or move forward on the case without that evidence. I think 3603 controls. I think there's no jurisdiction. To the extent that this court finds that there is jurisdiction, I would say that the state here has not sufficiently briefed the issue of why the court erred by failing to grant their motion to reconsider. Motion to consider hearings are limited to just a couple of things: whether or not the district court misapprehended the facts of the case, misapprehended the party's position, or misapprehended some kind of controlling law. The court in this case actually stated it's not an opportunity to make a backup argument, which is what I believe that they were doing here. Moving on to sub-issue 3, Gonzalez is a really interesting case. Thinking about Terry v. Ohio and the actions of officers in this case, Gonzalez really does two things for the citizens of Kansas. One, without Gonzalez, cases like this could happen here, where the officers are actually interfering with, in my opinion, the investigation. They had him doing finger tests. They had Mr. Weaver doing ABCs while the investigation or the medical exam was going on. Wasn't really clear to me whether or not who was in front here, whether or not the officer was in front of this investigation, or whether or not the EMTs were in charge of this medical exam. But it does seem clear that they were interrupting the exam, and I think that that's what Gonzalez is. One of the things that Gonzalez is here to do is to stop that from happening. The other thing that Gonzalez says is that this is how we protect ourselves under the Fourth Amendment from pretextual public safety stops. There's means to protect ourselves from pretextual stops in other instances of Fourth Amendment law, but Gonzalez is here to do that for the citizens of Kansas.
Excuse me, counsel,
Sir.
but looking at the facts of this case, I can't see that the officer was doing anything wrong. This person was seen slumped over the steering wheel in a busy traffic situation. And I would be puzzled to have somebody, show me that that was not the right thing to do.
I just have one follow-up question. Which officer, Judge? There was two officers. There's Neal and Purdon. Neal was the first to arrive, and Purdon arrived.
I think it was Purdon.
Purdon?
I'm trying to remember which one was which.
Well, I'll just pop down my list here. So my problem with Neal, who's the first one to arrive, the first thing that he did is he took his license and said, you can't go anywhere. He seized under the Fourth Amendment. That is not a public safety stop. That's outside the grounds that we allow for public safety stops. His immediate questions was, have you been drinking? So he didn't smell alcohol. No one ever smelled alcohol during this whole thing. And he asked if he knew where he was. Mr. Weaver said that he knew exactly where he was, cited the exact intersection. And Neil actually stated on the record.
Like, even a public safety stop, just trying to get kind of the lay of the land. Have you been drinking? Do you know where you are? I mean, those seem to be reasonable questions related to the safety of this individual, because the most likely, or one of the more likely things that could happen here when somebody falls asleep at the wheel is they've been drinking.
That's one of the
He
things.
said, I'm tired. Okay.
Sorry, Judge.
Go, yeah.
That's one of the options, and that's what Gonzalez does, Judge.
Right.
It makes sure that that is the option.
I mean, I agree with the point about taking the driver's license, but just asking the question, have you been drinking, do you know where you are, is consistent with a public safety stop, don't you think?
I agree, Judge. I used to be an EMT.
Yeah.
I mean, I've dealt with this.
Right.
But, we didn't take people's licenses.
Right.
And then the problem that I have, going back to you, Judge, the problem that I have with Purdon here, and I think that's what the district court focused on, is his actions. He interrupted the EMTs for 5 to 7 minutes. That's what the district court judge said. He was in the car doing DUI testing while the EMTs were still on scene before they cleared him. We don't know if what the EMTs were doing at that time, but it's very clear that Purdon took over this investigation. It's very clear that Purdon, I believe, first of all, that Neil did violate Gonzalez. I also strongly believe that Purdon definitely violated Gonzalez here. And again, he also did not smell alcohol, and I understand she needed DUI just on prescriptions. But at that point, what the district court judge said, that there's no evidence of a DUI at this point, but they're beginning their investigation anyway. Unless there's no other questions, I'm willing to waive the remainder of my time as well.
Other questions? No? Thank you very much, counsel.
Thank you, Judge.
I'll give you a minute.
Well, let me
Okay.
just interrupt you with some
Well, you may
questions.
have more than a minute.
As it turns out, I've got the transcript of this July 12th hearing, and after the judge granted the motion to suppress, the district attorney said that he wanted, Judge, for the record, I would like to reserve an opportunity for a potential appeal and also for a potential motion to reconsider.
Right?
And then the prosecutor said, I would like to take an opportunity to discuss this case with the other attorneys in my office to figure out how we're going to proceed.
She's a young new attorney, correct?
And then the court indicated it could be set on a scheduling docket.
Correct. To see if the state would file anything. If the state didn't file anything, this case would presumably be dismissed. If the state did file something at that scheduling docket, they would figure out a time when everybody could convene to hear the motion.
But it wasn't, that's a little bit different than scheduling the motion to reconsider on August 1st. The court just said the next scheduling docket happens to be August 1st. If you file something, we'll take it up then.
Right. The court, I never argued the court was going to take up the motion on August 1st, only that we would set it out for a scheduling conference to see if the state would file anything.
All right, thanks.
State v. Evans is case number 116022. As I said, it was this same panel of this court convened here, but across campus in the other building. 2017 Westlaw 544565. Gonzalez is the case that Mr. Weaver hinges his entire argument on, essentially. But the quote here in Gonzalez at page 455, once the officer has completed the inquiry necessary to satisfy the purpose of the initial detention, the public safety stop here, the interaction about EMTs and all of that, when medical was cleared and Mr. Weaver said he was done with them, he or she, the officer, must allow the person to proceed unless the officer has a reasonable suspicion of criminal conduct. By the time in this stop, Mr. Weaver said he had visited with the medical officers that you can see in the video, and he said, I don't want to be transported, I don't want to go, I'm done with medical. By the time he had told that to medical was the priority of the call. You can see it in the video. By the time he told that to officers, officers absolutely had reasonable suspicion to proceed
What's the
with a DUI.
impact of them taking his driver's license from the get-go?
A public safety stop is a detention. It is a seizure. Officers can seize somebody for a public safety stop, and until the public safety stop is resolved, he can be seized. They could have boxed him in with their cars. They could have taken him out. The impact of holding the license is of no consequence here because the initial stop was never challenged here. The initial public safety stop is not what's at issue. In this case, it was never challenged at the district court. He never argued that by holding his license at the outset that was problematic. It wasn't then, it isn't now, because officers had justification to pursue that public safety stop. By the time the public safety stop ended, they had reasonable suspicion to proceed to DUI. To say officers at the conclusion of that medical episode had to clear the scene or risk tainting this public safety stop is just an absurd outlook on how officers do their jobs. To require them to say, Mr. Weaver, since you won't talk to EMTs, I know you were passed out behind the wheel at this intersection, but I've got to let you go. That can't be the case.
Questions from the panel? Okay, thank you very much. We'll
Thank you.
take this matter under advisement and issue opinion as quickly as possible. All right, with that, that concludes, and counsel, you're more than welcome to stay in case there are questions from the audience to counsel in general. But we are willing to answer any questions any of you may have about the Court of Appeals, how we operate. We just cannot answer any questions about these particular cases. And I notice we have several of the attorneys still here, and we have another attorney in the audience that I'm sure would be willing to answer questions too. So with that, do we have any questions? Now's your chance. Yes, ma'am.
Can you explain a little bit further to everyone what your job is as the judge, how that's different at the trial level versus the appellate level?
Want to take that, since you had both?
Well, I'll try to take a stab at it. At the trial level, I don't think you would have had judges grilling the attorneys the way we do here. At the trial level, the judge just needs to let the evidence come in, especially if there's a jury who's going to be the fact finder, and the court doesn't typically interject itself and question the attorneys the way we did today. Once it goes on appeal, though, then it's just a matter of having legal issues before the court. We're trying to figure out if there was any error below. And so when you get to an oral argument like we get today, it's typically filled with judges asking various questions. Maybe we don't even sometimes let the attorneys get their argument out, but we have very specific questions about the case, and we want to ask them and get answers for them, and so that's why the hearings proceed the way they do.
And as a follow-up, then, how does the appellate court decide which cases to hear as oral argument?
We don't have this court doesn't have, which cases to decide an oral argument, or which
ones to hear oral arguments?
Okay, well, first let me say that we don't have any choice in which cases come to us, because if you have a hearing in district court or before an administrative agency or anything, you have a right to appeal to our court. So as an intermediate appellate court, we take all the cases that come to us. If they are dissatisfied, if the parties are dissatisfied with the decision from our court, then they file a petition for review, which we mentioned earlier, a petition for review with the Kansas Supreme Court. And then they can decide to take the case or not take the case. And of the 1,600 cases, opinions we issue a year, they end up taking from us about 110 maybe, where they'll accept petitions. They will grant the petition for review to consider the case. As far as how do we decide what cases are to be orally argued, when the parties file their brief, they have an opportunity to request oral argument. So that would be the first thing we would look at. Did the parties request oral argument? If they did not request oral argument, we may still look at the issues and determine whether or not we think those are significant enough issues that we will have lots of questions on and want to answer. If we do not select the case for oral argument, but the parties really believe it should be orally argued, they can make a motion to us after we've set it and say we really want oral argument on this case. Or if we as a panel get the case and start to look at it and say, you know, we really think that oral argument would be beneficial here, then we can set the case at that point for oral argument. So there are lots of stages along the way, and we try to give the parties a say in whether they want it or not.
Many of the cases that we hear are criminal appeals, many of them having been filed by the defendant, him or herself. And often they would be tickled pink to be able to get out of prison for the day and come over to Topeka and argue the case. We're usually not going to grant that unless there is some significant reason why we want to hear that case. Because we know, prisoners want to get out for a day.
Yes, ma'am, right here.
When you say you hear the oral arguments, if you're not listening to oral, are you just reading the brief? You're just making your decision based on it?
Yeah, probably only about 25% of the cases that come before our court actually get orally argued. The rest of them, 75%, we're just getting in the briefs, reading them, discussing among ourselves, and issuing a decision from the briefs and the transcripts. And as you can tell from this oral argument, we are very familiar with the case by the time they get here for oral argument. We've read the briefs. In many cases, we've delved into the transcript of the trial. We may have read the entire transcript of the trial. And so we know, and we don't generally discuss the case, the three of us, before we come for oral argument. But individually, after reading everything, we kind of know what questions have come up to us that we want to, like why did you look at this case, or what's your best response to this? Because that's what is what is going to help us decide. So although I know attorneys, it's very nerve-wracking to stand there and not know what questions are going to be asked and be prepared to answer, but really the best thing that could happen is that we ask a lot of questions, because that gives them a clue as to what is going to be important to us, and they can focus their short 15 minutes on that.
What, did we have about 20 cases this docket, and we had oral arguments on 3?
Yeah, so when we finish here, we will sit down, the three of us as a group, and decide all 20 cases. So we'll see how that goes. Okay.
Well, you just went right into my question. Can you please explain how you go about, as a panel, rendering the decisions in cases?
Uh-huh. Do you want to take that, Joe, or you want me to?
All right. Well, as you note, there are 3 of us. And there's a reason for that. And that is, if you have 3 judges discussing the case, you're probably going to get a more full explication of what the positions are on each side. And so prior to deciding these cases, we have the opportunity to read over the briefs, to read memorandum that are prepared by research attorneys, and we therefore, even if we don't have oral arguments, we have quite a bit of information that has been given to us on what is the appropriate disposition on this case. And so most of the time we will sit down and we'll say, well, what do you think? And it will go around and we'll discuss it for a while. It may not take long if it's a simple case. It may take a lot longer if it's a more complex case. And so mainly it's talking among ourselves. And then after we decide it and an opinion is read, it's available to our colleagues on the court to look at our decision and decide whether maybe they want to add their arguments to it. Now, you know, the answer comes from the three of us, but we listen very carefully to those things that are said by our colleagues, because oftentimes they come up with very good things that perhaps we didn't realize were there.
And it may be, for example, this afternoon when we sit down with these 20 cases, that, you know, we'll go around, each will state our opinion as to what we think on the case. We'll trade information, you know, I mean, that's really one of the wonderful things about an appellate court versus being the sole decider in district court. With three people, you really have people bring up things that you didn't think about before. And you may read it and think, oh, I understand this. This should be like X. And then your colleague will say, well, yeah, but what about this? And it's something you never thought about before. So it's really a very dynamic process. Now, it may be, as we discuss the cases today, there may be some cases that we feel, well, you know, we really don't feel like we have enough information on that case. So we may talk to our research attorneys about going back and getting more information, or one of the judges may say, you know, I kind of agree with you, but before I decide how I want this case to come out, I need to go back and do some more information. And so then we'll reconference the case later. It could be that the case gets written up and somebody changes their mind. I mean, you know, it's all, until that case is out and published, it's a very dynamic process. It could, I've had cases before where you write, the practice in our court is, if the decision is 2-1, the one has to write a dissent. You don't just get to say, I dissent, you have to state the reasons for the dissent. There have been cases where we've gone through this whole process, the dissent presents their case for the other two to consider, and the other two say, you know, I think you're right, I'm changing my mind. And so it flips so that the dissent becomes the majority opinion. So all of this is going on all the time. And it's, I mean, it's very, very interesting. And I think we try very, very hard to come to the right decision. And we try very hard to come to a unanimous decision. So, you know, I think you would find our court compared to many other courts around the country. We do have dissents and we do have concurrences that are filed, but it's fairly rare. They're usually unanimous decisions, and that may mean we limit the case a little bit from what maybe one or the other wanted to do, because we can all agree on X, even though we may not agree on Z, Y, and but we can come together on an opinion that we can all agree on. Yes, ma'am.
Probably a dumb question at this point.
No, there aren't any dumb questions.
So, as you had said before, you get all the information ahead of time before the oral arguments. Is it possible that you all come to a like decision ahead of time, listen to the oral arguments, and if there's no changes in you all being, you know, unanimous in the decision, are you allowed to make a decision right then and there?
Orally at the, you know, like we could say,
During this whole process, like after you have like the case, you know, arguments, are you?
you've been on here longer than me.
Like I said,
We've never done it that I've known.
Theoretically, it's possible, but no, we wouldn't do that, because the last stage, the actual writing of the opinion, can bring changes. I heard one Southern judge say, you know, every once in a while, we find a case where that dog just don't hunt, you know? And when you're writing the opinion, you may all of a sudden discover, well, wait a minute, this was very clear to me during oral argument or during conference, but now that I have to sit down and write in great detail why we are doing what we are doing, I see some problems with it. So we may well change our minds, and that happens. But we're not going to do that right at the time of oral arguments, because then you miss another opportunity to look at the case and maybe come up with some additional issues that should be addressed.
And you know, when we disagree, it's very collegial. I mean, it's never like, oh, Joe, you're such an idiot. I mean, it's never like that at all. It's always, and often a.
Why am
person-
I always the one who's the idiot? I
don't
just,
It's always, there are times when the majority may say, I think you should write a dissent. I think this position needs to be put out there so that when the Supreme Court is looking at a petition for review, they can see both sides laid out on this panel. So, we don't get angry when somebody writes a dissent or a concurrence. It's usually adds to the issue in some way, shape, or form. Mhm.
I have a question, hopefully I can get it. But anyway, I noticed, I'm not talking about the case, but I noticed that when you come to the panel in your discussion, like versus Martin versus this and whatnot, so do you have a research person that pulls those for you, or do you just know them all?
Oh, we know every case off the top of our head. Well, there are some cases that in certain areas of law are just well-known. So the Martin case, for example, is a well-known case. But the parties in their briefs will have alerted us to certain cases. So that tells us that what cases we should be reading ahead of time and looking on. And then our research attorneys will also find cases that they think we should look at. And we have one of our research attorneys here. Callie is a research attorney for Judge Malone. And so she helps pull everything together. When the case first comes in, the research attorney gets the whole file and tries to kind of summarize the facts for us and outline the parties' arguments. And so very, very helpful work. And they work very closely with the judge they work for.
Also, Callie is a former student here, so.
She's amazing.
Have somebody like that.
Yeah, otherwise, we're a high-volume court. So, we may have 20 cases this docket. There have been dockets when we've had 30 cases, and you have one oral argument a month, so you've got to read those cases, be prepared on those cases, write those cases, and then be ready the next month for the next group of 30. So it's high volume. We can use all the help we can get. Yes, ma'am.
Does an attorney's delivery have much impact on the outcome?
Their delivery,
Or, help with presentation and, to what degree do you base it just on their brief or their,
well, I think I'll give each of us a chance to answer that. I mean, kind of the question is, does oral argument kind of help, can it help or hurt your case? Or I don't know that oral argument can hurt your case, but there have been times when an attorney is really just has hit on the issue so well in a way I never thought about it before, that it certainly changed my position or made me think about something I never thought about before. So it can be very important. Joe, do you?
well, I pretty much follow that. Many people say, well, does oral argument do any good? And I said, yeah, maybe in 5 to 10% of the cases, it may impact on the decision, not necessarily the result, but perhaps the reasons for the result. And there have been times when I have gone into the courtroom to hear arguments totally convinced that one side was correct. But during the oral arguments, during their arguments and our questions, I said, well, wait a minute, I think I'm wrong on my first impression of this, and go the other way. So not real often, but because everyone's had the opportunity to write briefs. And those are the main parts of the appeals. That's where the cases are discussed and applied to the facts. But yes, every once in a while, the oral argument does impact. Maybe not in a major way, but in a significant way.
Malone?
We don't judge the cases based upon the eloquence of the oral presentation, if that's what you're asking. You need to have the law and the facts in your favor, or else you're going to lose. I've had cases where only one party showed up for oral argument, and we wound up ruling in favor of the party who didn't even show up because the law and the facts were in their favor, and that's what we try to go on.
I think also if any of you out there are thinking of becoming attorneys, going to law school, and maybe the attorneys here could address this, but I think a lot of people overlook the amount of written advocacy that is done by lawyers. So you really need to hone your writing skills and be able to write persuasively, because that may be the only chance you get to get the judge's attention. And although we see attorneys on TV doing these amazing cases in court and oral advocacy, I would say probably most of their advocacy before a court is written advocacy. And I don't know would you all agree with that, or, I mean, you can disagree. Yeah. Yeah. Yes, ma'am.
So kind of bouncing off the question she just asked, what are your expectations for first-time attorneys or any attorney that's coming in front of the Appellate Court for oral argument?
That they be prepared, that they know their case, that they have looked at the weaknesses of their case as well as the strengths, and they're ready to respond to those questions. I think you guys were really, really fortunate today. We had some wonderfully skilled appellate advocates today. And they were able to answer questions. You know, they weren't backing down to any, you know, as we tried to point out weaknesses in their case, they were standing firm, and, you know, that's good oral advocacy. So, you know, just to me, preparation is, they need to know that case better than I should not know the case better than they know the case. So, other questions? How many of you want to go on to law school, do you think? Good. We used to have the whole room raise their hands. What? Well, yeah, I mean, paralegals are very, very important to the whole process. Do you all have the attorneys that are here, do you have paralegals? No?
Yes, our firm, we have several paralegals. One of the paralegals has been with the main partner for 30 years, and I go to her with questions. She's extremely well-versed and very knowledgeable, so it's a critical role in my practice.
Do you guys have paralegals in the appellate public defender's office, or? Yeah. Yes, ma'am.
Now that you've heard these cases, when will the decision be made as to the reversal, if any?
The reversal? They're all going, no, no. Our internal rule with our court is that we will get all written opinions filed within 60 days of oral argument. And I don't have any reason to believe that that would be any different in this case. Now, as you heard when I said sometimes you'll write a dissent and then the panel will switch, and sometimes that there are reasons that delay that outcome, but generally, and I think really our last statistics that we did showed that on average we get the opinion out in about 38 days. So we're pretty, I think, pretty intent on getting a decision and getting it out quickly, not only for the benefit of the parties, but remember, we're then facing the next month of cases. So they have to move pretty quickly. So I would hope that 60 days from today, you'll know what our decision is in these cases. Anything the attorneys here would like to add to the group, or? Okay. Thank you very much.